My comment would be this. We don't really know what Act 372 says as far as its ramifications. That's my problem. You know, what exactly is it? What standard has been set other than harmful to minors? And that's really no standard. I think you need a judicial determination, which is usually the way that obscenity, any kind of question related to the propriety of literature, poems, whatever. That's how it's determined in a court of law, and I think that's what needs to be done here. One way or the other, you know. But to say the standard is harmful to minors, that's not really a standard.
But is it not a legal term?
Harmful to minors, no, I don't think it is. I think the test, I'll give you an example of tests for obscenity and for adults, for example. Appeals to prurient interest. Has no redeeming social value. That type of thing. And those are the type of tests that, you know, that really hadn't been spelled out specifically to determine in a court of law as to whether that should be the test for minors or something more than that. And that's what I think. I think we're kind of flying blind in a sense, not knowing what the test would be. That's why I advocate going into federal court and getting the judge to say, this is what the standard is. And this could go all the way to the U.S. Supreme Court. I mean, you know, this is not just happening in Little Rock, Arkansas. So I mean, it's something that I think needs to be determined and needs to be determined. So, I'm not saying we'll go to the U.S.
Well, I anticipate it. I mean, it's the elephant in the room. We all know the culture that we're in right now. I anticipate it going far, which is why I'm concerned about the money and the funds, which is why we still think we need that judicial clarity. There's clearly a group of co-plaintiffs who can become the plaintiffs, and they can take this. So what I understood from last week, Mr. Adams, you talked about the contemporary community standard, and that was what we used to determine the harmful to minors term. Is that correct?
That is
Am I understanding? I do not profess to be a lawyer.
There is a general constitutional test for what counts as obscenity and can therefore be essentially criminalized under the U.S. Constitution. And it's got three elements. You know, as Bob said, one of it is the average person applying the contemporary community standards would find that work appeals to a prurient interest in sex, meaning somehow an abnormal or pathological interest in sex. The second prong of that test also involves the average person in the community hypothetically applying the contemporary community standards to find out if the work is also patently offensive to standards in that local community. And then the third prong, as he says, is that the act lacks scientific, literary, other kind of similar value. So there's two parts of the test that do involve prevailing community standards, and that's part of what creates some uncertainty about how the standard would get applied in practice.
The community standard of our patrons, would that be for cows if this were to come up? Say it's Act 372 is held up, would that then be of the peers of cows, or would that be of all Arkansans? Or who defines what community, I guess?
That's a great question. Courts of Arkansas have not been clear about that. It's either so say that Nate got charged, you know, with an 8 felony for having all his art blue on shelves here. Generally, the two options might be that the community standards of Pulaski County, or perhaps the whole state, as to whether that book is patently offensive, would determine whether he would have a defense to that criminal charge based on the second prong of this harmful to minors statute. Maybe another thing to help with the backup and explain is harmful to minors is a variation on the general obscenity standard, but just to apply to minors. So part of what gives that harmful to minors statute its very broad breadth is because almost all of us think that there are things that might not be patently offensive or appeal to the prurient interest of adults, but would be patently offensive and appeal to the prurient interest of children because they don't have as well developed everyone agrees that that's a much broader category than what would be constitutionally obscene as to